in the last 5 or 6 years, another huge case that my law firm has been involved in is very significant, is the marriage equality battle. As we all know, same-gender couples were prohibited in California from marrying because of a family code section that was in our law. It was called Prop 22 that was passed, and so we fought that battle and said that was unconstitutional, a denial of equal protection, and we won in the California Supreme Court. But then Prop 8 went on the ballot. Prop 8 was the same language as Prop 22, that a marriage is the union between a man and a woman. And then, because that passed by a slim majority, but yet a majority, then we had to file yet another lawsuit challenging Prop 8. And we represented originally a lesbian couple and also a gay couple who were in long-term committed relationships. And in this battle, we fought once again to vindicate the rights of couples who wish to marry. We all know the unfortunate decision of the Supreme Court of California not long ago in reference to that battle on Prop 8. And our feeling is that in the same way that marriage is for better or for worse, some decisions of our Supreme Court of California are better, but this one is for the worse. We are very, very disheartened and dismayed and shocked that the California Supreme Court validated the constitutionality of Prop 8, permitting a majority of the electorate to deprive and deny what our Supreme Court just last year determined was a fundamental constitutional right to marry for all otherwise eligible adults in California, regardless of sexual orientation. Our California Constitution, Article 1, Declaration of Rights, Section 7A, says that, quote, a person may not be deprived of life, liberty, or property without due process of law or denied equal protection of the law, end quote. It does not say that all persons, except gays and lesbians, are entitled to equal protection of the law. And yet that concept now seems to be newly embedded in our California Constitution as a result of the recent Supreme Court decision. The idea that California law would permit a 50% plus one vote to deprive a minority group of its constitutional protections and have our Supreme Court defer to the majority will of the electorate is, we believe, contrary to the constitutional foundational principles upon which our California and United States Constitution are founded. The will of the majority should have no bearing whatsoever on constitutional protections. That is what is beautiful and unique about our Constitution and our nation. If the will of the majority was the rule, we would not have had desegregation of schools in 1954, because clearly the majority was in favor of racial discrimination and segregation at that time. Further, if our courts deferred to majority rule, interracial marriage would have continued to be illegal, as it once was in California. And the court would not have struck down the ban in 1948, Perez versus Sharp, and in 1967 in Loving versus Virginia, which was a U.S. Supreme Court decision on interracial marriage, as unconstitutional. So this decision may lead some groups to pursue future constitutional amendments which would embed even more discriminatory practices into our state constitution. We're concerned that an initiative that excludes gays and lesbians from the right to marry may be viewed as authority for future propositions to bar them from certain occupations, such as teaching or judgeships, or from the enjoyment of such basic rights as adopting children or becoming foster parents, all of which rights our California Supreme Court has previously afforded to individuals who are gay or lesbian as basic constitutional rights. Even if 99% of the electorate decides to pass a proposition to take away fundamental rights from a minority group, that should have no bearing on the court's obligation to protect a minority and safeguard their fundamental and inalienable right to marry or any other fundamental constitutional right. Thank you. We think that this decision is as shameful as was the United States Supreme Court decision in Plessy versus Ferguson, upholding separate but equal, which was ultimately reversed and criticized in Brown versus Board of Education. So although we are pleased that the court upheld thousands of marriages that took place after marriage licenses were issued between June 16, 2008 and the passage of Prop 8 in November 2008, because the court agreed with our position in our brief and oral argument that Prop 8 should not be applied retroactively, it's a shame that other gay and lesbian couples will be denied the fundamental right to marry that Prop 8 couples and all heterosexual couples are able to enjoy. I might add, even a person on death row, Scott Peterson, convicted of murdering his pregnant wife and the fetus that she was carrying, has the right to marry. But law-abiding, committed same-gender couples who love each other are denied that right, and that is absolutely outrageous. So our next move should be to educate the public as to the necessity of another constitutional amendment to restore marriage equality. Do you agree? So the trend in the public view of marriage equality is to support it. 49% of Californians now do, which is many more than existed years ago. We look forward to winning in the court of public opinion and in the ballot box as soon as an amendment supporting marriage equality can be placed on the ballot. We shall overcome. Thank you.